Okay, today is April 15, 2013, and we're finishing up learning Module 6, right? And I have on the board the lecture from last week, just to remind me of what we did last week and to review it for just a minute. We kind of flip-flop things. Learning Module 6 is supposed to be about investigations and children and justice in the context of investigations by DCP&P and by law enforcement. We did that already, and we're going to talk a little bit about the major part of an investigation, that is the investigative interview of a child. So we're kind of flip-flopping, and we're going to do what the subject matter was for learning Module 5, investigative interviews in State versus Michaels. But just taking a look at how we wrapped up last week and the week before that, we talked about the different witness types and how to approach different kinds of witnesses. The most important witness of all being that first person that the child made a statement to, what we call the fresh complaint witness. The fresh complaint witness. And I explained how that witness can give you insight into the credibility of the accusation. Because if you look at who the child told and the manner in which they told and the language that they used to tell, you can kind of size up, whether this case has some legs, whether this case is credible or not. And the other reason we look very closely at the first person that the child told is it can give the interviewer a heads up about that child's potential to be interviewed. If they make a statement like, I don't want this person to get in trouble, or is daddy going to go to jail, or am I in trouble for this? If they made any kinds of statements like that to the guidance counselor or to the DCP&P worker or to their aunt or mother or whomever they told the first time, that suggests that they may be reluctant to talk about what happened. They may not want to get that person in trouble, so they may minimize what they tell the interviewer down the road. How they told, their feelings when they told, the kind of language that they use when they told, not only can give us insight into whether it's true or not, or credible or persuasive, but also can give the interviewer a heads up. And when we talk about investigative interviews in a moment of children, you'll see more about what I'm talking about. But we talked about that last week. We talked about talking to the perpetrator, and how to approach the perpetrator, how perpetrators think, the wrong way to approach a perpetrator, the right way to show understanding, to tell the perpetrator that they're not bad, that they made a mistake. The last thing you want to do is judge them or be dismissive of them, or certainly to be aggressive or coercive with them. That's a recipe for not getting any information from a person who stands accused. It's like anybody else in life. If you want to get information for them, you got to treat them nicely, especially perpetrators. Everything you see on television is the wrong way to do things. Yelling at people, hitting them with notebooks, and terrorizing them doesn't get information, right? It looks like it works, but it doesn't. Take it from experience. And more importantly, if you're going to resort to those strategies, what good is the information? If information came because we were coercive or threatening, then that information is what we consider involuntary, and I wonder whether it's even truthful or credible. You want the information to come out from the perpetrator's mouth, not yours, and because he or she wants to do the right thing, because they understand their mistake. You want to let them know they're not like everybody else. Okay, they're not bad. We all make mistakes, and this was just one of them. It's a very, very powerful and effective way to get information from people. We talked about State versus Flowers, State versus PZ, and State versus Halua. What were those cases about? Someone tell me Flowers, Halua, and PZ. What issue did they address? The one case we looked at.
Interviewing the person in jail when the worker, I guess, is serving in like a law enforcement capacity.
Exactly. We're talking about the role of DYFS in talking to perpetrators, and whether there's an obligation on DCP&P to advise them of their constitutional rights, and in what context that obligation might arise. And we all agree that the division doesn't advise suspects of their Miranda rights Nevertheless, once in a while, a worker interviews a perpetrator at the jail or maybe the family home or some other place, and the issue of whether they felt threatened or whether they should have been advised of their constitutional rights arises. And what did we learn from Flowers and Alua and PZ? What kind of situation requires suspects to be told of their Miranda rights? I'm sorry? Well, I'm not asking when.
Is it where? If they're like incarcerated or something?
Well, that's one example, if they're incarcerated. And if they're incarcerated, that's an example of being in what? Custody. And when people are in custody, when their freedom of movement is curtailed, when they don't have any options, when they can't get out of the situation that they're in, people are more likely to feel intimidated. And the courts have not said that it's not okay to interview people in custody. It's perfectly okay to interview people in custody. But if you do, you have to tell them what? They got rights. And the two big rights are what? A right to what? An attorney and the right to not talk to somebody. And Flowers, Halua, and the case that mentions those cases, Flowers and Halua, PZ, which was among your readings, they addressed that issue. You know, when and in what context DCP and P might have had the obligation to tell a perpetrator or a suspected perpetrator their constitutional rights under the Fifth and Sixth Amendments. Now, there were two cases or two situations. One guy, actually there were three cases, Flowers, Halua, and PZ. Two of those guys were interviewed where? In jail. And that's a custodial situation if there ever was one, right? They're in a cage. So there, they should have been advised of their constitutional rights. The PZ guy, that was the case you read, where was he? Where was he when these DIFUS workers stopped by that day?
Was he at home?
He was at home, right?
Yeah.
And who else was home with him that the court made a note of? And they said, well, you were home, man. His father? That's right. His father was there. He was home. He was in a place that was comfortable to him. He knew the worker from the past. There was nothing coercive or intimidating about the environment that he was in. So in PZ, the court said, we don't even have to get to the issue of whether DIFUS was acting as law enforcement would, because he wasn't in custody. And there was nothing about the context of that interaction that would suggest that he would think he was in custody. So that's DCP and P and Miranda rights, and we wrapped things up last week by talking about hearsay. And the reason why hearsay is very important for the average law enforcement person, and certainly for DCP and P intake workers and those of you who are out in the field, interviewing people, gathering information, whether you're in a school, whether you're in a daycare center, whether you're in a family home, wherever you are, you're going to encounter witnesses, and witnesses are simply people with information for you. You're going to encounter witnesses who have information, and the information that they share with you might involve some of these hearsay exceptions. Now, while this is a legal concept, you're a first responder. So when you're out in the field gathering information, if we don't know how that person expressed themselves or how that person related to you, how someone else expressed themselves, we, the Deputy Attorney General or the attorneys for the prosecution, we don't know whether those statements might be admissible under the hearsay rule. So the more precise you are, the more colorful you are, the more detailed you are in documenting information from witnesses in the field, the more likely it is that we might be able to get in this information under the hearsay exception, or one of the hearsay exceptions. We talked about the excited utterance, right? And we also agreed that hearsay is an out-of-court statement. Somebody said something out of court, right? Billy told the guidance counselor what his grandpa does to him. His guidance counselor heard that at school. His guidance counselor comes to school to say what Billy said. So it's an out-of-court statement because Billy said it to the guidance counselor at PS 18. Billy ain't in the courtroom. The guidance counselor's in the courtroom. And she's telling us what Billy said. So what the guidance counselor is about to utter in the courtroom in my hypothetical is an out-of-court statement. PS 18 ain't the courthouse, right? So it happened out of court. It's being offered in court by the guidance counselor, and it's a statement of another person. not the guidance counselor. Tell us what Billy said. That would be hearsay, but sometimes those kinds of statements are admissible, right? We all agree that hearsay is unreliable. We analogize it to that game of telephone, where you tell somebody by the time the end comes, it doesn't look anything like what was said at the beginning. So the courts have, for centuries, concluded that hearsay is unreliable. But sometimes it is reliable, depending upon how it was said, where it was said, who it was said to, and the context of the statement. Excited utterance was an example. What about an excited utterance makes it more reliable? What is an excited utterance?
A heat of the moment type response.
A heat of the moment type statement, for example.
Usually immediate. A lot of times.
Usually immediate about what? What's the immediacy related to?
Whether the immediate awareness of the situation, whether they were excited because the person brought it to their attention right away and they panicked and they're uttering it, or they saw the incident happen and it's what's coming out of their mouth fast and quickly. They don't have time to really
Exactly.
panic.
When Suzanne talks about immediacy, she's talking about in relation to the incident. You heard a gunshot, you saw a car accident, you experienced something, and in the telling of it, you're excited by that incident. And it's considered more reliable because there's not a lot of time to reflect when you're in a nervous or agitated state. Perhaps it's best to think of it in terms of spontaneity. It's kind of a spontaneous, excited statement. And the courts have said, well, that kind of hearsay may be admissible. So if little Billy, in the course of an interview, by the child study team person, discloses matter-of-factly that Grandpa comes in his room and fondles his penis at night, that probably won't come in under the excited utterance exception. But if Billy began to sob and say, I don't want to talk about that part of my life, and he began to shake a little bit, and his speech patterns began to increase, and his voice began to get a little higher, and he kept looking down at his feet, and then he made this disclosure in this agitated, excited state, it might come in. But no one will know that Billy made that statement in an excited, agitated state unless the frontline worker or law enforcement documents it. And in this case, you'd be talking to the guidance counselor, right? And that would be the fresh complaint, going back to the fresh complaint. And she needs to tell you how Billy acted, or the child study team worker in my last hypothetical, how little Billy expressed himself. And unless we document what the guidance counselor said, he began to look at his feet, his face became flushed, he began waving his hands around, he started to cry, his voice became high-pitched. Those kind of details help whoever hears this recounting of what happened assess whether it meets excited utterance exception or not. And if we simply write in our field report, Billy disclosed to child study team evaluator that Grandpa comes in his room at night and touches his penis, then there's a piece of hearsay that may have been admissible for the DAG and family court that is forever lost because it wasn't documented properly. That's why understanding hearsay is so important for frontline professionals. Okay. If Billy was 8 years old, well, we probably wouldn't need the excited utterance. We could probably rely on this thing called the tender years exception. What's the tender years exception? How old do you have to be to meet the tender years exception of the hearsay rule? Under 12. And it has to be a statement about what? Physical abuse?
Sexual abuse.
No. Sexual abuse. Okay? And does it have to be sexual abuse upon Billy, or can he talk about witnessing his sister being sexually abused? On Billy. If you look at that, and it's in the, I put those PowerPoints up in the announcement board. You look at the PowerPoints, it's a statement about sexual abuse perpetrated upon that child who's under 12. But that's not the end of the inquiry. Those are your basic elements: child under 12, statement about sexual abuse upon the child, right? Those are the basic elements, but that gets your foot in the door. Then you have to convince the convince the judge, rather, not the fact finder. You've got to convince the judge that it's trustworthy. And we talked about evaluating trustworthiness. When you size up what the child told, what Billy told the child study team evaluator, what would you look for, or what are some examples of things or behaviors by Billy that might indicate that that statement to the guidance counselor, to the child study team evaluator is trustworthy? What do we look for?
Consistency.
Consistency in the telling, very good. If he told it one way at the beginning of the disclosure, and he told it similarly at the end, and throughout the account, that's real good stuff. What else? Spontaneity. And spontaneity suggests that it came from him, spontaneously. He brought it up. His child study team, the worker didn't bring it up or offer it as a possibility. And it doesn't mean that it's the end of the issue if the child study team person said, have you ever been abused by a family member? You know, but that just means that it's less spontaneous. So we want to look at all the aspects of that statement to determine its trustworthiness, and spontaneity is one, consistency is another. What else?
Well, the context that it came up.
Yeah, how did it come up? Again, what does that mean, though? You know, what elements of the context? Spontaneity is
Well, like
the
the
context.
terminology that's used.
Well, that's different.
Age-appropriate terminology.
That's a different issue. Correct. Age-appropriate terminology we look for, right? Did the child at age 8 express himself in a way that we expect 8-year-olds to express themselves? Or was he using language that was inappropriate? Language that was developmentally inappropriate? Did he express himself in a way that an adult might, which might make us skeptical? However, not every utterance by a child who's 8 that might be age inappropriate or sound like the words of a grown-up is suspicious. Sometimes they have learned those words from the molest itself, right? You know, and that's something else we look for. Idiosyncratic statements. Well, every now and then I have to go down on grandpa. 8-year-olds don't know that. That is the language of a grown-up. That is sexual slang from grown-ups. But the way it came out suggests that he learned it from grandpa. And it might not be a bad thing. It might add to the credibility of the statement, right? Idiosyncratic statements. Developmentally inappropriate statements. Those things. What's a statement against interest mean?
A kid being afraid that they're gonna get punished.
A child who thinks they're going to get afraid they might get punished. So they make a statement thinking that they're going to get a whooping or get in trouble or get grounded, yet they make it anyway. Who does that? We don't offer information generally that's going to get us in trouble or grounded or hit or whooped or beaten with a belt unless it's true. I mean, if we're going to make up something on somebody, we're not going to make up something that, you know, inures to our detriment that gets us in trouble. So, again, that doesn't mean it's absolutely true. It's just one of the factors that courts look for to determine whether the statement of the child was trustworthy or not. Declaration against interest, a statement against interest. What's something that happens sometimes in an interview where the interviewer gets something wrong when they're talking to the child? What might happen in that context where we might be able to argue it helped us understand the statement better and consider it more trustworthy?
Correct facts.
When the child corrects the interview. I think you all got that. So that's good stuff. Right? So let's move on. Well, I'll move back a little bit. Oh, one thing I'm going to tell you about the fresh complaint witness. You may even have this on your final exam. I talk at length in this course about a fresh complaint witness. We've talked about it for 4 weeks. And it's the guidance counselor, it's the child study team person, it's grandma, it's Aunt Cynthia, it's all the people that the child tell about their abuse that bring it to the attention of the authorities. Kid tells guidance counselor calls DCPAP. Kid tells Aunt Cynthia, she marches him to the police station. Okay, kid tells the neighbor, mom's not home, she brings him to the hospital, to the ER. Right? The person who heard the disclosure and alerts the authorities, we generally call the fresh complaint witness. But among your readings and among the lecture from a couple of years ago I asked you to listen to, I talk about the fresh complaint of rape. Now that's a different kind of fresh complaint witness. And we've kind of borrowed the term fresh complaint from evidence law from over 100 years ago to describe the people that kids tell that call the cops or call DIFUS that I just described, the person who brings it to the authorities. But the real origins of that term have to do with rape. And it was a rule of evidence that arose in the 19th century to allow the prosecution to explain to the jury that although an adult victim of rape didn't go to the cops right away, they did confide in someone they trusted. And the courts of the 19th century called that fresh complaint. Even back then, since time immemorial, rape victims don't always go to the cops right away. Even in 2013, they don't always go to the cops right away. Like kids, they weigh potential outcomes. You know, if it's going to be, I'm going to be in a worse situation if I go to the cops, why would I go there? And often they run it by someone they know and trust. And even in the 19th century, that was generally what would happen from time to time. So the court said, well, you know what, the prosecution's at a bit of a disadvantage here. Women who are adult victims of rape don't always go to the police right away, and the defense can use that against the prosecution or the woman, typically a woman, because like, oh yeah, she got raped, why didn't she go to the cops right away? Right? The prosecution was allowed, and is still allowed, to bring in the fact that the woman went to someone they know and trust, and the type of person they would normally confide in, and told them about it at or about the time it happened. Thus you get fresh complaint. It's really fresh complaint of rape. And the courts allow prosecutors to bring in that the victim told her sister or her girlfriend or even an old boyfriend or her mother or somebody that they would normally turn to for advice and counsel about what happened shortly after the sexual assault. We use it with teenagers. We're very fortunate in that fact that we have this tender years exception for kids under 12. You know, but sometimes teenagers get molested by their fathers or uncles or cousins or grandpas or some other person or a boy at school or a coach or someone else, and they don't tell right away, but they reported it to someone. So that kind of has a twofold purpose. It's a fresh complaint. It's the person they told, so we want to find out what they told that person, especially if that person brought it to the authorities' attention. But it also may be admissible under this fresh complaint doctrine, because they didn't go to the police right away or to the authorities right away. They told someone they knew and trusted. So it not only works in the 19th century, it still works today, especially for adolescents. So you have fresh complaint of rape, which is typically when an adult or an adolescent goes and confides in someone, and then the shorthand term fresh complaint, which we use generally speaking to describe all the people the kid told, especially the one in a child abuse case that called the authority. And I mentioned that in that lecture that you listened to. And you'll see in the learning module objectives, it says, be able to distinguish between the common law fresh complaint, that's the 19th century version, and the child abuse fresh complaint witness. Any questions about that concept, the fresh complaint? All right. Good. Let's go back to learning module 5. Oh, wait a minute. There's one other thing I wanted to touch upon with investigations. And you all read this article, and we're finally able to get it up there. Girls who disclose sexual abuse, urogenital symptoms, and signs after genital contact. You know, one of the issues in an investigation in child sexual abuse is whether there's medical corroboration. The expectation from the average person is that if a kid was touched, which is a euphemism for sexually penetrated, if a female child was sexually assaulted, that there would be some medical evidence, that there'd be some trauma there that's observable and corroborative. Even in 2013, a significant amount of people, when they hear their child may have been sexually abused, run right to who? The doctor's office. Right? Well, there's very rarely medical evidence, and there are a number of reasons why. We'll talk more about that later in the course. One of the reasons is that the female anatomy is designed for things to go in and out. So the expectation that simply by putting a finger in there or an object or even partially a penis would cause injury or lasting trauma is one that's just not true. Okay? It also comes from a misunderstanding of the hymenal tissue. Many people believe, and I thought this many years ago, that the hymenal tissue was a sheath of tissue that covered the vaginal opening, that any kind of intrusion would cause damage, when in fact the hymenal tissue is nothing like that. It's intravaginal, it's concave, like an upside-down contact lens, if you will. Its tissue is somewhat flexible, so it's not easily damaged, depending upon the age of the child. Adolescents are different from prepubertal. And it also has an opening, so things can go in and out. So part of the reason why people overrate medical evidence in kids is because of a misunderstanding of female anatomy. The other thing is kids don't appreciate the difference between in and on. Fortunately, in New Jersey, we don't have to prove penetration anymore. We never really had to, but there was this belief that we did. Now it's pretty clear in the case law that we don't have to prove actual penetration into the vaginal canal. Don't have to prove that. Nevertheless, people who question kids want to find out whether it was in or on. Because if it was in, it's 20 years, and considered more significant by most people than if it was simply on. But children, especially kids under 8, we talk a lot about language in kids. We talk a lot more about language in kids in the forensic interviewing course. Kids at that age don't have a real appreciation of their own anatomy. And so they may not know what it is to be in and on. They may not know that the vagina is accommodating and things can go in it. They may not appreciate that. So when we're asking them that question, if we have a thought bubble above their head, we might say in where, but they don't say in where. They just simply give whatever they felt. And if a penis goes between, and most of these offenders, this is the other end, most of these offenders put their penis between the legs, or they're bent over from behind, and entries from behind, and they rub their penis onto the butt cheeks, or onto the labia, onto the vaginal lips, and they achieve arousal that way, and ultimately ejaculation. Now, to that child, what does it feel like, man? Does it feel like it's on or in? I don't know. To some kids, it may feel like an in event. It went in between their legs, it went in between their butt cheeks, it went in between their, thighs, it went in between their vaginal lips. It may feel like an in event, when in fact it was an on event. And my point is that language can confound this notion of in and on, penetration or no penetration. And if it was simply on, as most of these events are, very few adult males have intercourse with children, ever. Some do, and in most cases they're going to be trauma. What we know more and more is that they achieve arousal, by rubbing their penis on the body parts. They're not stupid. And that's not going to leave lasting trauma. Obviously, the closer in time there's a medical evaluation to the event, the more likely there is some kind of injury. But these injuries heal. And you may see a video later of Dr. DeBellis, I don't know if it's later on down the road in this course, where she talks about the difference in that tissue too. She analogizes it to the tissue inside your mouth. If you bite your cheek, my son Daniel bit his cheek the other day, the world was collapsing. And 2 minutes later, he forgot it ever happened. And there probably was no injury either, because the tissue inside of your mouth heals very quickly, and from a cellular perspective, it heals differently than other injuries, other abrasions, other hematomas and cuts and bruises and those kinds of things. Okay? So that's why you got to take a look really fast, shortly after it happens. And that's very rare that we have that opportunity to look shortly after it happens. Okay? Now, most of you were able to listen to that podcast that I did with the guy at the end there, Martin Finkel. Lago, she's from Philadelphia, Devlinger's from Finkel's down in South Jersey. I don't know who Schroeder is, but they were all co-authors of this article here. And what Finkel and his colleagues suggest is that maybe we're looking in the wrong places. Again, that doesn't mean we shouldn't look at kids, we shouldn't take pictures, we shouldn't look at their anatomy to see if there's injury. We should still do that, but we've all come to the awareness that there's very rarely that kind of injury. But is there another way that medical evidence can help us understand whether there was a molestation of a child? And he says, and his colleagues say, listen to the kids. Get the history. ask them about how they felt when it happened, how they felt after it happened. Okay? And what he's among other things, he's pointing towards the fancy words dysuria, I think. It means it burns when you pee. And if kids report dysuria or burning when they pee, at or around the time they claim to have been molested, that is corroborative of child sexual abuse. And that's why he said, girls who disclose sexual abuse, urogenital symptoms and signs after genital contact. And there's a number of things that he and his colleagues focus on there, but the most important one is dysuria. As he says in the conclusions, sexually abused girls who experienced direct genital contact frequently reported symptoms related to the abusive episode. These symptoms were reported most frequently with genital-to-genital contact. The information sheds light on the mechanisms of injuries, some light on the mechanism of injury leading to symptom reporting can be used to further study. Now let's see what he says. That wasn't the conclusion I was looking for. Yeah, I don't know how this PDF is not responding to my touches right. Oh, the other thing is, UTIs, urinary tract infections, is the other thing that they're beginning to believe there's a causal relationship between UTIs and genital-to-genital contact. And so that's what he says here. We found that UTIs are uncommon explanations for urogenital symptoms in sexually abused children. The girls and many more reported experiencing genital pain, dysuria, and genital bleeding associated with inappropriate genital contact. Dysuria is a symptom of genital irritation. Genital pain and bleeding have also been associated with genital trauma. When these symptoms are temporally related, which means close in time, to the inappropriate genital contact, in the absence of alternative explanations, these historical details can serve to support the child's allegations that contact occurred. So here's another way, a different way perhaps to look at medical evidence. And, you know, the way is to do, and this is really for doctors, this information, the way is to do a comprehensive history taking and to talk to the child and give that child the opportunity to provide details about how their body felt, not only that day, but the next day. Now, my colleague, Lisa Squitieri, just tried a case where a child had UTI and dysuria and reported it on multiple occasions where the mom took her to the ER at least twice. And I remember this article, and I gave it to Lisa, and I said, we need to get these doctors in. And we did, and we got Dr. DeBellis from the Children's House, and for the first time that I'm aware of, we were able to get this into expert testimony. That there was, now the defense was able to say, well, she could have got a UTI from 35,000 different possibilities. True. And dysuria can arise from lots of different things. True. But in this case, she said she was sexually abused, and she reported it, and there was other evidence, okay? And she experienced it and was taken to the doctor's office twice at or about the time she remembered or reported that she was sexually abused. You know, so she couldn't be making, you know, she didn't understand the correlation between dysuria and those symptoms and sexual abuse. I mean, if it was a hoax or was fabricated, then did she also fabricate that? So, you know, we lined up her repeated trips to the doctor, complaining of dysuria and 2 diagnoses of UTI with the molest, got it in for the doctors, and he was convicted. Not solely based upon that, but certainly it couldn't hurt, I'm sure. And that's another way to use medical evidence. And that was the point of reading this article. And also, you know, when I interviewed Finkel on that podcast, he had just published this article, and he was pretty excited about it. So let's go back to learning module on investigative interviews. Now, I said to you last week that probably the most important witness in my mind is the fresh complaint witness next to the child. Of course, the child, whether it's a physical abuse or a battering or a sexual abuse case, clearly the child and what they're able to report is the most important witness. That's what the judge or jury needs to hear. That's the person or their statements that take center stage in the family court, right? So what they have to say about what happened to them is critical in whatever forum you are in within the justice system. So there are ways to approach child witnesses that are more defensible in court than others. And I want to talk a little bit about those kinds of things. And this is chapter 4 in Myers' book. Now, Myers points out that in the early days of child abuse investigations, lawyers in the family court and in the criminal courts had a tough time cross-examining these children. Some of the strategies that they used to get in people's face, to accuse them of lying or having a motive to fabricate, they didn't sell well in the courtroom to the jury, and they didn't prove to be very effective in the family court either. So the defense bar, the lawyers who challenge the kids, who represent the parents or represent the accused, had a tough time. And then things began to change for a variety of reasons, and the defense bar began to focus not so much on the child, but on who? Who did the defense bar start attacking in the 1980s? The interviewer. This was a stroke of genius for them, because now they could be kind to the child and mean to the grown-ups. So the grown-ups who took the stand to testify about what the child said to them and the questions they asked and the nature of the interview they conducted were front and center now. And the child, they could simply say, was misled by the grown-ups. They're innocent little children who don't know what they're doing, and they're very vulnerable to the suggestions and to the coercive nature of these investigative interviews. So the attack shifted from the kid to the interviewer in the 1980s. Myers starts out his chapter on investigative interviewing of the child with that observation. Well, if that's the case, what is it about the interviewer that is vulnerable? What is it about the interviewer that would become the subject of cross-examination in either the family court or the criminal court? Well, the big concern is suggestibility, right? Or leading the child, or misleading the child more appropriately. The notion that the grown-ups, the interviewers, might be putting ideas in the child's head that weren't there before, that they may have planted the seeds of these allegations during the investigative interview phase, so that when the child takes the seat in the family court, or goes in chambers to tell the judge what happened in a guardianship or a termination of parental rights, or they sit in the witness chair in a criminal prosecution, that child is not testifying from what they experienced, but rather they are testifying from what was suggested to them or offered to them by the adults, and they eventually adopted and offered to them by the adults so many times that the children come to believe that these things happened when in fact they didn't. So, you know, we have a whole course on forensic interviewing. I'm just going to go over some of the basics here. So what can that happen? And if it can, how do we rebut that? How do we address that? How do we make it less likely that it is so? What can we do to be better interviewers? And just how vulnerable are children to suggestion? How well do they remember stuff? Well, one of the observations that Myers and most researchers have made over the years is children can remember stuff pretty well. Even preschoolers can remember things pretty well. The challenge with preschoolers is communicating that. Children know more than they can tell. And that's a maxim or a saying that we use in forensic interviewing. They know more than they can tell. So the challenge for investigative interviewers is to unlock that information and unlock it in a way that they can express themselves in a developmentally appropriate way. So children's memory capacity is significant. Don't think they don't remember. It's not perfect in children and adults, but it is significant, and even quite young children are able to recall personally experienced events well over extended periods of time. Now, for your purposes, I just want you to know a few kinds of memories, okay? Because it'll help us appreciate what issues are in play in an investigative interview when it comes to suggestibility and leading questions and all that. The purest form of memory is called free recall. Free recall. That is the kind of memory where the witness simply provides a narrative about events in the past. You say to them, tell me about that. What happened on your ride to school today? That question asks for free recall. It contains no information, and your narrative about what happened on the ride to class tonight comes solely from your words, your recollection, and your ability to express that recollection to the interviewer. That's free recall. Another kind of memory is called recognition memory. Recognition memory is the kind of memory that comes out of people, kids too, people, through the use of cues and prompts and aids and anything really, a question perhaps, that helps orient them or cue them as to what you're asking about. Where I might say to you, tell me everything that happened on your ride to class tonight. That would call for free recall. If I said to you, tell me everything that happened on your way to school today when you watched that car crash into the toll plaza at exit 148 on the Parkway. Okay, now I'm cueing you. I'm focusing you on something you watched. The car hit the toll plaza on exit 148. Now, I don't know how the car hit it, what color the car was, how fast the car was going, who was in the car. A lot of stuff I don't know, and I want to get from you. But I'm tapping into your recognition memory through the use of a question. So free recall is that amount of information that a person can express without cues or prompts or help. Recognition memory is the kind of memory and information that a witness can provide when they're given a little help, a cue or a prompt, a little context. And it could be, like I said, a question. It could be this soda cup from Burger King. It could be nearly anything. One time I tried a case where a teenage girl, about 15 years old, was working in the Willowbrook Mall right over here. She was doing those surveys that are kind of annoying when you're walking down and they run after you with a clipboard and they want to ask you questions. I hope we don't have any former surveyors here. But you know, you're going to get to the store and they want to ask you questions, and these poor kids are making whatever minimum wage is, $6 an hour, $7 an hour, and nobody wants to talk to them. That's what she was doing that day when she ran into a couple of guys from the Clove Road Apartments here at Montclair State. They're now dorms. Back then they were these apartments that were part of the university. And they began to chat her up, and they began to tell her that they're going to get Jets tickets, and after they get Jets tickets, they want to come. She wants to come later to a party that was happening in the evening at the Clove Road Apartments. That would be really cool. She comes to the Clove Road Apartments. There was a party. There was about 6 or 7 people there. They challenged her. They said to her, we don't think you can finish the rest of this bottle of 151 rum and then jog around the track field with us guys. And she drank the 151, and she goes, I could still do that. No, she was 15. I could still do that. I can take the challenge. And they go, well, I bet you can't finish the rest of this. And I never heard of this kind of drink before. You guys might drink this stuff. Alizé or something.
Yeah. That's old.
That's old school, right?
Yeah, well, I was.
Yeah. Not me. I checked it out. I had to go. You know, when you're trying a case, you got to do a few things. And this all ties into recognition memory. But part of it was I had to go to the Great Knots and buy a bottle. Why not? It's impact on recollection. Anyway, this is all a scam to rape her, and rape her they did. She drank it, and she drank the other stuff, and the girls, there were some girls there, and they were like, "You guys are pigs, stay away from her," and blah blah blah, and the guys took her, and the radio station towers are over there, I think, and they walked down a path. She made it about 100 yards and fell in the dirt, took off all of her clothes, and they raped her. And one guy ran back, the guy who lived there, and he didn't touch her. They start screaming, "They're raping her! They're raping her!" And you know, I wound up catching this prosecution. One of the things I did was to try to help them remember the event. There were a couple of girls there that came afterwards to clean her up. She was full of vomit and blood. And those girls who saw her afterwards, one of the guys didn't rape her and left, and they became my witnesses. So I brought them back there, and I walked down the path, and we stopped where she had fallen, and then we went back to the Clove Road apartments, and we went in the apartment, we walked around. What does that have to do with recognition memory? Yeah, I'm trying to trigger the witnesses' recollection. I'm trying to get a feel for the scene of the crime. That's a different issue. But I'm trying to trigger their memories. And let me tell you something. They made statements to the police and they made statements to the investigators. But when I went there with them, I got all kinds of information I never heard about before. So here's what we know about recognition memory. It's not as accurate as free recall. I'm not saying it's bad memory. I'm not saying it's inaccurate memory. But I'm going to throw numbers out. If free recall memory is 90% accurate, recognition memory is 82% accurate. They're both pretty accurate, but not quite as accurate. And I made those numbers up. The point is that recognition memory is good, not as good as free recall. If you want the purest form of memory, you're going to go with free recall. On the other hand, people do better with recognition memory, and children do better with recognition memory, especially preschoolers. You cannot interview a preschooler without relying upon recognition memory or giving them helps, cues, and prompts. And we're not going to shortchange kids, and we're not going to shortchange preschoolers simply because of the demands of the criminal or civil justice system. If that's the way they remember best, then it's our obligation to talk to them in ways that retrieve that memory. They know more than they can tell. It's our obligation to get that information out in a way that makes sense and that speaks to their abilities. And I think the system and the law has come to that point where they allow a certain amount of that. At the end of the day, though, a good interview is one where the victim or the witness does more talking than the interviewer. You know, they ask experts, and I have to go to court periodically to look at videos and size up whether it's a credible video. If the interviewer's doing all the talking and the kid's doing very little, it's not a good interview. I don't even need to hear the questions, you know. On the other hand, the interviewer has to ask questions that have information to help put people in context and to cue them and to keep them moving along. So those are the kinds of things that you want to pay attention to when it comes to free recall and recognition memory. And those are the two big ones. There's another one called script memory. Script memory arises when we're speaking about something that happens repetitively. And people are unable to distinguish one incident from the other, so they kind of tell you the way it usually happens. Can someone tell me what an example of a repetitive event is in any person's life? It doesn't have to be a child abuse case, where things happen so similarly day after day that you really can't tease out. Getting up and going to school. Getting up and going to school if you're going to school 4 or 5 days a week. Yeah. A commute? Yeah. Yeah, you get on the subway every day at 8:02, you know, one day feels just like the other day when you get on the train or the bus or the subway or whatever it is. You know, every day you may take a shower, brush your teeth. I mean, brushing your teeth is script memory, you know. How much toothpaste did you use on Wednesday when you brushed your teeth? I can't remember. Can you remember any, other than this morning's perhaps, can you remember any toothbrushing? No. As opposed to any other this week? Over the past 4 days? It's just like a big bomb. I can tell you how I usually brush my teeth. I can tell you what I usually do. I can tell you about how much I usually put on the toothbrush. That's script memory. And you know what sadly happens? Sometimes kids are molested over and over and over again, and it is eerily and sadly similar. He comes in their room after mom and the kids go to sleep. It happens about 2 or 3 in the morning. He does A, B, C, and D. Week after week, year after year. And then maybe it changes and is a little bit different, and that happens week after week. You know, they're fondling when they're young, oral sex, intercourse. You know, you see this disgusting pattern. But the point is, for months and sometimes years, it's the same thing. So you get that kid in and say, what did dad do when you were in the 5th grade? Like, what did he do? What did he do? And he did it to me on the day after this 5th grade dance. And what did he do the day after? I don't know. It was the same thing as he did the day before the 5th grade dance, the day after. It's like trying to figure out how much toothpaste you put on the toothbrush on Monday and it's Friday. They can't do it. In those chronic abuse cases, kids are unable to tease out one particular incident from the other. So we need to know that as interviewers. We need to know that that kind of memory exists. And one way to approach it is to try to cue kids to think about incidents where it might have been just a little bit different, you know? Go ahead.
When you get those kind of cases where the kids are repeatedly raped and molested over and over for years and stuff, and you guys get the case, do you try to prosecute the mother?
Well, wasn't that a discussion board or is that in forensic interviewing? You're in both classes. 1 in 5 mothers doesn't believe their kids. Yeah, most of the time we don't prosecute the mothers. The mothers are, they're in a very weird position. If they knew about it, knew 100%, where to open the door and dad's having sex with their daughter and they didn't tell, they're going to get charged. But to impute, to argue, to charge them based on they should have known, or how could they not know, it's sadly easy to not know for years. Because we trust people. This is our man or our woman, man. Listen, if your husband takes your daughter to the quick check, and they take 40 minutes, she's only 10 minutes away. Do you go, he must have been having oral sex with her back in the quick check? Who thinks that? Diapers workers. Normal people don't think like that.
He probably can't do nothing.
Nah, he's got a lot of freedom. Although he wants LeBron sneakers.
Oh, you gotta get him.
Let me tell you something. I don't understand this. All it takes is one parent. If the parents had the resolve not to buy these $200, he's 11. His foot, you know how tall he is? I bought him sweatpants about a month ago. He's going, no, they don't. They do. He's right. He's growing so fast.
Yeah.
I'm talking in a matter of weeks. It's ridiculous. He's right at that age, I guess.
And then a couple.
I'm going to buy him $200 sneakers so that they can not fit in a month. And these parents, well, Jimmy got them and Billy got them and Tommy got them. They do? I know those people. They are not affluent people. Believe me. Okay? They're dropping $2 bills on these custom-made Kevin Durant's or whatever. So I told him that he has to get a job. Well, not quite that. I said, listen, you have to understand that, I could pull out $200, but I had to earn that money. And I'll pay 1/3 of the sneakers. I will raise your allowance from $3 a week he was making, doing nothing. Doing anything. Take the garbage out once a week.
He's only $3. Come on.
He's only 11.
He's only 11. So, you know how long it's going to take him to get them sneakers? It's going to be another $3.
He doesn't even know. He's playing out.
I gave him extra things to do, chores, and I raised his allowance to $10 a week.
Oh, that's a big jump.
That is.
Because he's doing a little, it's not much more. He's got to take out the recyclables now, and he's got to walk the dog, which he should be doing anyway. And, one other simple task. And he wants the sneakers, so he's been doing it. And, you know, he's up to, we're gonna cash in his coins, and he's gonna, you know, he's up to like $40 since we had made this deal. By next Sunday, he'll have 50. I'm gonna give him 70. And he'll have those sneakers, listen, he'll have those sneakers in a month and a half,
Yeah.
and he'll respect those sneakers. He will respect those sneakers.
But I'm just
Okay?
worried about him, when you go to buy him, they like sold out. I mean, I like sneakers, so, you know.
He's nothing sold out. You order them online. You size them at the store, you order them online. He'll get them.
You have to be careful with that.
Don't
Make
order
backfire.
overseas.
Because then, once he gets those, there's gonna be new ones that came out that are
Yeah,
gonna be even more
now
expensive.
you don't have to worry.
Well, now he works for that. That's the point, you know.
He's
I'm-
not gonna get it.
That's-
That's
he
works that hard.
There's gonna come a point where
No, he's got to, listen, I'm not going to give him 1/3 all the time. I told him that. I'll help him.
That's a good way to do it.
Yeah,
It's not worth it.
Better than buying him like the other parents are buying him.
This is not
Look
worth
at all the kids
it.
with iPhones. They like in preschool with iPhones.
It's not worth to get another iPhone.
Yeah, well, they subsidized those down to $99, but I understand what you're saying.
So if they were $99, then it would have been a problem. Let's say the sneakers.
No, he don't even have $99 sneakers. I go online, I get him a pair of high top N1s. They fit him beautiful. N1s, high tops. He plays basketball. He never knew anything of these sneakers were perfectly fine until about a month ago. Now it's different. That's the age that they're entering. Let's get back to memory.
He's gonna remember that, all right?
Cued recall, C-U-E-D, that's a way of tapping into recognition memory by showing them an object or a question, offering them a question with information, or taking someone to the scene of the crime. That's a way to cue recall and to tap into recognition memory. Now, suggestibility is what we're all concerned about in these forensic interviews, okay? And suggestibility refers to the susceptibility of memory to error or distortion. That's in your book. It's on page 114, yeah. You know, it's, if you're thinking in terms of, it's the process of putting ideas or recollections into a child's head. It's influencing their memories through words or behavior. Improperly influencing their memories through words or behavior. And we have to appreciate that there's no simple relationship between age and suggestibility. While generally speaking, preschoolers are the most suggestible, the most likely to adopt what's suggested to them by an adult, some preschoolers are better than others. Okay? So there's no simple formula for determining whether a child is vulnerable to suggestion or not. But research has taught us that preschoolers are the most suggestible. Kids between 5 and 8 are suggestible, but not quite as much as preschoolers. 8 and 11, a little less suggestible. And kids over 11 are no more suggestible than adults. Once a child reaches about 11, 10 or 11 years old, children are no more suggestible than adults. And simply because preschoolers are the most suggestible, and they are, doesn't mean that they can't be questioned effectively. We just have to be more vigilant around preschoolers than we are with older kids. So there's no simple correlation between age and suggestibility, but we can draw general conclusions about preschoolers, grade school kids, and kids over 11. We do know that people and children are more suggestible about the peripheral details than they are about the central aspects of what happened. So if a child was held down by a perpetrator and he put his mouth on her vagina and licked her, and she described that event, the core details, the central details about what he did are usually pretty firm. In the sense that if we said, well, did he put his hand there too? No, just his mouth. He didn't put his hand there. Did you feel stubble on his face? That's a suggestive thing. And if she felt this, whatever stubble means to her, but if she offered that spontaneously, that would be a very powerful idiosyncratic detail. Remember we talked about idiosyncratic details? And if they felt a little bit of beard on a man's face and they offered that without us offering it to them, that would be great. But if we even offered that to them and say, could you feel the hair on his face? No. Because they're not that's a central detail. They remember that pretty damn good. Put his head there, it's something that's very interactive, very sensual, and not sensual in a sexual way, but the senses can feel it. And if you offer them bad information or make suggestions, they're pretty resistant. They're not as suggestible about the core details. But if you say, it was the late afternoon, wasn't it? Yeah. Or the light was off, wasn't it? The door was open. Those are peripheral details, right? Central details, guy's got his head between the child's legs. She's reporting how he had his head on my coochie. That's a central detail. That's a big part of what happened. Whether the light was on or off, what time of day it was, what the temperature was in the room, what color his socks were, was he wearing long pants or short pants? Those are peripheral details. And kids are more suggestible about peripheral details. So if you go, could you feel his beard on your face when he had his head between your legs? No, not really. We threw something out there, not so suggestible. And he was wearing long pants, wasn't he? Uh-huh. They might be more willing to go with that, because it's not a central detail. More suggestible about the peripheral details, less suggestible about the central details. Got that? The other thing you need to be mindful of, when we talk at length in the forensic interviewing of children classes, you don't want to demonize or talk badly about the subject of your interview. So in child abuse cases, it's almost always the suspected perpetrator, right? Maybe the father, the uncle, the stepdad, the coach, whoever. You don't want to stereotype or talk badly about the perpetrator. That is insidious or harmful in a different way. It is suggestible in a different way. We're not suggesting things for the child to say, but we're suggesting a way of thinking. For example, the coach didn't only touch the girls in this team, he touched girls on another team. Did you know that? Did he touch you? Right? He belongs in jail. Guys who touch girls are supposed to be in jail. And I just want to find out whether he touched you and make sure you're safe. Because the coach is a bad man. Research has shown us that when you demonize or talk badly about the subject of the interview, kids are more likely to say negative things about that person. So stereotyping the accused by calling them bad or evil or wrong or mean or in trouble or belongs in jail, or whatever way that you cast negative aspersions or negativity about the subject of the interview, is suggestible in the sense that the kid is more likely to say negative things. So while you're not telling the kid, say that he did this, say that he did that, or you're not offering, that would be coaching. You're not offering, well, did he do this, did he do that? You're not offering possibilities to the child. You're asking questions. But by negatively describing the target of the interview, that child has been primed to think negatively, and in that sense, you're being suggestible. So that future questions that call for a response from the child are more likely to be expressed in a negative way about the perpetrator, because we declare the perpetrator a bad guy. So it creates a hostile atmosphere, if you will, in the interview room with regard to the target, Grandpa, Uncle Mike, Uncle Sal, the coach, whomever. Stereotype and an accusatory atmosphere can be problematic, especially with preschoolers, as you might expect. Another situation where suggestibility is problematic are ambiguous events. Ambiguous events are events that are capable of multiple interpretations. And in the child abuse world, there are a few common ones. I'll give you them. And you know them if you work in diapers. Bath time. People be touching children's private parts. It could be innocent or it could be criminal. Because they're privileged. It's ambiguous, right? It's capable of multiple interpretations. So there are ways to interview kids. I'm not going to teach you that today, but there are ways to try to figure out whether it's bad or good. But my point is, in that situation where it's capable of being bad or good, is he touching her vagina to wash or touching her vagina to molest?
Is that the same thing when changing the diaper?
Very good. There's another ambiguous circumstance. Changing the diaper, bath time, wrestling, horseplay, karate, roughhousing. That's always the dad and boys, or uncle and boys, or, Jerky Jerry Sandusky. It was 4 in the morning. I was totally nude with one of the boys snapping towels. It's very common to snap towels. Hey, I was in a locker room in high school. Yeah, there was a few towels snapped. It was 4 in the morning. I was naked with a boy. We were horseplaying. That wasn't that ambiguous to me. But dads, uncle, people horseplay. Daniel, all he wants to do is wrestle, jump on me, elbow me, knock me down, pull moves on me that he watches on the TV. That's very common. It's very natural. It's very normal. But it's very ambiguous. If somebody reports, sexual abuse in that context, it's just like a bad. Medicine application. You ever have a medicine application case? Oh, it's putting best trace diaper, this kind of diaper, this. Ambiguous. These are ambiguous situations. In those kinds of situations, kids are more suggestible. Kids are more suggestible. They're more likely to take the bait if you offer some out. Well, was he putting the medicine on with his finger? Was he using a rag or no rag? That's where you got to be careful. Just let the kid tell what happened. Now, did he use a sponge when he was washing your coochie or not a sponge? Tell me what he did. What did he use to wash your coochie? What part of his body did he hold, whatever he used? The point is, in these ambiguous contexts, kids are more suggestible. Does that make sense? They're more likely to bite at something you throw out there because they don't even know what the hell's going on. They're confused about what's going on. So if you begin to give them information that helps explain either one way or the other, they'll adopt that. In some cases. That doesn't mean you can't ask kids questions about ambiguous events. Of course you can. Just be careful because they're more likely to adopt suggestive questions as part of their recollection. Now, when it comes to interviewing children, Professor Myers brings up an area where there's some degree of controversy, and that is the interviewer's knowledge of the facts of the case. There are basically two camps of forensic interviewers around the country. Some who believe in blind interviews, and some who believe in informed interviews. I am a proponent of informed interviews. But there are many legitimate and smart people out there who think that you should do a blind interview and not know anything about the case. Why do you think some people would argue that you should interview a kid without knowing what the allegations were or nothing about the kid or the case?
You definitely won't be suggestible then.
Because you don't have any idea what happened. You might have a sense that you're at a child abuse unit or something, but I hear you. Exactly. The assumption is you're going to be totally more neutral, totally more objective, and highly less likely to be suggestive or influential to the child. On the other hand, we started with the proposition that witnesses, and especially kids, need help remembering, especially the smallest kids. They don't have very good free recall memory. The only thing we got is recognition memory. And kids come to us with a disincentive to talk about what happened. So if we don't know how the kid feels about the abuse, the words that they use, their relationship with the perpetrator, how their mom or guardian reacted to the abuse, we're at a disadvantage when we go into the interview room. The words that they use for their body parts. We don't interview children, we interview this child. And if you live by that mantra, if you will, if your philosophy in forensic interviewing is that you interview this child, you need to know this child as much as you can about them. And at the end of the day, whether you're suggestible or not will be determined by the video that's made of your interview, or by the account of your interview. People who are informed can still do good interviews. You just got to be vigilant. And sometimes you might have to talk to the child about things that you learned about her during the forensic interview. The child's behavior and emotions and reaction to the abuse is critical. An understanding of that information is critical to your success in the interview. Because most of these kids have a disincentive to tell. They don't want to talk to you. And they want to protect, in many cases, the perpetrator. Or certainly, if they don't want to protect them, they don't want to see them get into trouble. So they're going to go out of their way to give you as little as possible. And without knowing about the molest, about the context of the molest, about the relationship with the perpetrator, how the people around them feel about the molest, you cannot deal with the emotional and psychological barriers and blocks to their statement. So, but nevertheless, there's two camps there. The blind interview. Most people subscribe to the informed interview, by the way, not the blind interview. Professor Myers also addresses the impact of multiple interviews on memory. Multiple interviews can be problematic. Now, in forensics and in child protection, we don't do multiple interviews generally. It's usually one and done. In clinical evaluations and in psychology, they do multiple interviews. And there's nothing wrong with that either. The thing is, multiple bad interviews can be more suggestive than a single bad interview, right? So the more suggestive you are, and the more suggestive you are across multiple interviews, the more potential there is to corrupt that child's memory. Just remember that. Although we do a single interview in child protection and law enforcement, in most cases, you're still able to get enough information to do what you need to do in the vast majority of cases. You don't know all the details, but you're never going to know everything, ever. Even the therapist who conducts 5 interviews or 50 interviews, you're never going to know the whole story. The best way to get information is to do multiple interviews with a single well-trained interviewer. The best way to get information from children is to interview them multiple times by a single well-trained interviewer. We don't do that. Nor do we have the luxury of ever being able to do that in child protection and law enforcement. But if you want the most information and the best information, to go at it incrementally is the best way. But it's got to be the same interviewer. They got to know what they're doing. Different interviewers, it's a mess. Because different interviewers express themselves differently, they interpret the child's behavior and language differently, their conclusions are different, and the kid may be answering what is believed to be the same question to 2 different interviewers when it's not the same question. It sounds like the same question. Where were your clothes? Were your clothes on and off? On or off? Both of them might, child reports the clothes were off. Other one says child reports the clothes were on. And when the child heard the where were your clothes question, she's thinking whether they're in her bedroom or the living room or on her body, and who knows. But two questions designed to get the same information can be interpreted very differently by the child. Yet at the end of the day, when they write their reports, they're both just writing their conclusion. Child says clothes were on, child says clothes were off. So it's just an example of how multiple interviewers can be problematic and lead to different results. Now, one of the things that's up there is Margaret Kelley Michaels. I'm going to end today by talking about her case real quick. Margaret Kelley Michaels was a prosecution that had its origins in the 1980s, the mid-1980s. And it wasn't until the late 1970s that people in law enforcement and child protection really began to take a serious look at the sexual abuse of children. Now, there were prosecutions and child protection interventions in the 60s and 50s and 40s, but they had to be solid cases. If the kid had syphilis, or there was an eyewitness to the child being raped, there would be criminal prosecutions. But intrafamilial fondling, intrafamilial and intra-household molestation and coaches and priests and these kind of molests, very rarely believed, very rarely diligently and effectively investigated. It wasn't until the late 1970s that these kinds of cases began to come out of the shadows. Unfortunately, among the mantras that grew out of the late 70s was, believe the children, always believe the children. The children are telling the truth. Sometimes the kids get it wrong. Sometimes the interviewers get it wrong. And to blindly believe the children is not a good practice. And it led to some troubling outcomes in the 1980s. And nearly all of them arose in the context of institutional abuse investigations. That is, investigations at the daycare centers and schools and the like. Margaret Kelley Michaels was one of the prime examples of that. And that was right here in New Jersey at the We Care Daycare Center in Maplewood, New Jersey, where she was a 24-year-old or 20-something teacher's aide who had come from Pittsburgh, Pennsylvania, and moved to suburban New Jersey near the Maplewood area and took this job. And it arose from a little boy who was having his temperature taken rectally by the pediatrician. His mom was in the room, and he made a statement like, Miss Kelley does that to me too. And the mother was concerned. It's like, what do you mean? Who? Miss Kelley? Miss Kelley? Anyway, she concluded that Kelley Michaels was what the boy was talking about, that was his teacher at the daycare, at the We Care Daycare, and she was putting something in his anus. The boy was interviewed, and a couple other kids were interviewed, and they got some statements. What they reported were statements of abuse, and then they interviewed all the kids. And then the DIFUS workers came, and the prosecutors, detectives came, and the Maplewood police came. And the word was spreading like wildfire that there was a woman molesting kids at the daycare center, and anybody who had a kid at the daycare center called their kid aside and asked them a million questions before the cops or child protection ever talked to them. And then child protection talked to them, and then the cops talked to them, and then the prosecutor talked to them. And at the end of the day, Margaret Kelley Michaels was, not the end of the day, but over a month or two, she was on the wrong end of a 139-count indictment, where she's prosecuted for penetrating kids, spreading peanut butter on their genitals, licking them, eating the peanut butter, putting forks and knives in their anus and in their vaginas, spreading the kids with peanut butter and have the children perform sex acts on each other and lick the peanut butter off each other, playing the piano in the nude, and on, the most bizarre and plausible things one might imagine. Nevertheless, she was convicted and went to prison. And after her 5th year in prison, she was released by the appellate division of the state of New Jersey. The appellate division said, listen, we don't know what's true or not in this case, but one thing we do know is the way these kids were interviewed was shameful, and it needs to go back to court, and there needs to be a new trial, And the court has to make a finding that these kids actually remember what happened to them, rather than their memory being the product of coercive or suggestive questions. So the appellate division reversed the conviction, and she was released on bail. It went to the New Jersey Supreme Court, and they affirmed the appellate division on everything, including this issue of whether the kids' memories were tainted by the investigative interviews. And they introduced something called the taint theory, T like Tom, A-I-N-T like Tom, the taint theory. And that requires prosecutors in certain cases where the child is typically a preschooler or maybe a little older, and there's some evidence of suggestive questioning, it requires the prosecutor to prove by clear and convincing evidence that the kid remembers what happened to them, not because the investigator shoved it down their throat or put the ideas in their head or were suggestive or leading, but because they actually experienced it. They call that a taint theory, and it came from the Margaret Kelley Michaels case, T-A-I-N-T. The case was eventually dropped by the Essex County prosecutor, and Margaret Kelley Michaels went on with her life. It wasn't only Essex County, it happened in Minnesota, Florida, Washington State, Texas, California, North Carolina. They all had their Kelley Michaels case. Believe the children. Yes.
So when you first heard about it, did you believe it or you didn't believe it?
Well, you know what? When I first heard about it, I was in law school. And, I didn't know a heck of a lot about it. I had no connection to child abuse. I was 24 years old, but I happened to go to the We Care Daycare Center because I worked for the Victims of Crime Board in Newark. And this case was being prosecuted then, and the parents wanted to have a meeting with the people from the Victims of Crime Board that helped pay their medical bills and their out-of-pocket expenses and lost wages because of the crime. So I was an intern. And I went there with the psychologist, and that was it. There was no lawyer. They go, oh, you're a law student, you can go there and answer the legal questions. Well, there was a wild-eyed mob there. These were the parents of those kids. And there was, back then, it was just like it happened. I didn't know what the facts were. I had no idea. But to the parents and to the system, this woman molested all these kids. She's the worst scum of the earth. And I went there in that environment. The place was packed. They were asking me about Discovery. I didn't even know what Discovery was, man. That was a bad scene, man. I shouldn't have gone there. But I remember the case. Coincidentally, I happened to be involved in it for that little bit. And they were professionals. I mean, these parents were plugged in, and these were upper middle class parents, man. And they were gunning for bear, man. Some of them were lawyers. More than a few were lawyers who were yelling at me, man. But you could see, looking back, I can see the context in which this information flowed. You had all these plugged-in people all talking and chatting and interviewing their kids. And just that meeting itself showed me how viral this stuff must have been in 1985 in Maplewood, New Jersey. Rest assured, none of these people simply went home at night and didn't discuss it. And they call that cross-contamination. When one person talks to another person, that person talks to another person, everybody's yakking, and they probably held meetings and everything. It's bad. It led to a terrible outcome. Any other questions about that? And you got the McMartin case here, which is in your Learning Module 5 discussion board. That was the California preschool case. And they made an HBO movie about that one called Indictment. Okay. Let's see, what's coming here? Okay, you're going to begin confidentiality and sources of confidentiality, and we'll do that next week. Then expert witnesses, and we're almost done. I'll see you a week from today.